We only have 5 matters, so I'll just go through the list. We'll start with Adanya Rooney and Christopher Rooney. I think I see.
I'm here, Your Honor.
So Adanya is in the waiting room. Let's get her in. And Ms. Call is here, who was appointed the guardian ad litem. So we're here for an interim review with the guardian ad litem, and then I think I set this to check in with the parties as to how visitation was going and to see if we needed to make any adjustments at this point. Why don't I start with Mr. Rooney, then I want to hear from Ms. Rooney, and then we'll go to Ms. Call. Okay, Mr. Rooney?
No, I think everything's been going good. We've been following pretty close to the basic times. I had an issue with Monday for like phone calls just because Myra is in counseling during the time that we had originally appointed for that. So I talked with Adanya through the Talking Parents app and let her know, and she was fine with that. So we just did a different time.
So you were able to work out a different time on your own for that?
Yeah. The only issue is I'm not always able to use the app because my grandma has a flip phone, and if I'm at work and it's her time to call, then she has to call my grandma's cell phone number. But I already had a conversation with Miss Heather about it as well.
Okay. All right. Thank you. Ms. Rooney, any comments you'd like to make?
No, I think we've been doing pretty good with communicating and trying to work together to make sure we're meeting the needs. Okay.
Ms. Call, have you had a chance to meet with the parties?
I have, yes. I've been able to spend a bit of time with both parties and also with Kiddo. And I have to say I'm really impressed with the communication between both sides of the case. I think both parents are demonstrating that they are genuinely acting in the best interest of their child. And I do have some concerns around the allegations that were made and the seriousness of the court orders. That's in my interim report that I submitted to you. I'm not comfortable yet recommending more visitation for Ms. Rooney just yet. I would like for both children to continue receiving treatment. And as you can see in my recommendations, I'd really like for both parents to have some tests done, some evaluations done. Particularly Ms. Rooney, I know has been through a lot over the last several years, and I would really like for her to be able to have a psychiatric evaluation. I know she's currently receiving some treatment. I have yet to see any assessments, and so I am working on getting those, and I know I've made Ms. Rooney aware of that.
Ms. Call, I don't see your interim report in the file, so I'm going to ask you to specify.
Sure, yeah, it was filed. It was filed yesterday. I'm sorry, it's not there yet.
Yeah, if you file it the day before, it's not going to get scanned in. So either
I apologize.
In the future, and this would be for anybody listening, if you file something the day before the hearing, you're either going to have to email it to me or deliver a bench copy that would get routed to me. So
Gotcha.
Why don't you tell me what those recommendations are?
Thank you for your patience with that, Your Honor. I apologize.
You bet.
My recommendations were that Mr. Rooney remain the primary parent and that visitation should remain as it's currently ordered for Ms. Rooney, which means the first and third weekend of every month, in addition to 2 weekly phone calls via the Talking Parents app. I'm happy to hear that they're able to converse about that and do things as is necessary for the family to work in a positive way. I'm happy to hear that that's going on. The breaks and holiday schedule should remain as it's currently ordered. There has been some hiccups around timing of communication for asking for more time. Mr. Rooney seems very open to giving Ms. Emerson more visitation when it works for Myra's schedule and for the family's schedule. And so I think if Ms. Emerson can give more notice when she's wanting more time, that may work out more in her favor. I recommended that Mr. Rooney obtain a mental health assessment as well as a hair follicle test, and that the results of that should be passed on to me. I recommended that Mr. Rooney seek out counseling and mental health treatment to address trauma, anger management, and domestic violence issues. I also recommended that Ms. Emerson obtain a psychiatric evaluation as well as a hair follicle test. There is some concern recently around substance abuse that I think needs to be addressed. I know Miss Emerson suffers from some pretty serious medical conditions that keep her in a lot of pain, and so that should be acknowledged in the testing as well.
Give me those two recommendations again. I was writing.
Sure, for Miss Emerson,
Yes.
that would be a psychiatric evaluation as well as a hair follicle test.
Okay.
Go
ahead.
I would like for Miss Emerson to provide the court with any current assessments she's been given through her current mental health counselors. We have yet to receive anything along those lines. I recommended that both Mr. Rooney and Miss Emerson participate in a state court-approved parenting course so they can continue to learn how to co-parent together for the health of their daughter. And then there's the other things along transportation, decision-making being Mr. Rooney's along those lines. I would love to see visitation increase for Miss Rooney as long as we can. My biggest concerns are around whether or not she's taking seriously the allegations of what's occurred with their daughter. I believe the statements that have been given by several people in the family regarding her son's behavior. It's deeply troubling. I have yet to spend time with him or get into his records, but I would, that's my goal this next week, is to make sure that that happens. I would like both children to be able to experience uninterrupted treatment before we start increasing visitation. My biggest concern at this point is that in my conversations with Myra, I believe that Myra is still having unsupervised time with her brother, which has been specified by the court to be a very serious thing. Their bedrooms are right next door to each other on a different floor from Miss Emerson's bedroom. That's very concerning to me. I think the situation is not being taken as seriously as it needs to be. I was not convinced that Miss Emerson believes the accusations or has taken necessary steps to prevent further unwanted behavior.
All right, thank you. Ms. Emerson, any response to all of that?
So for Myra's bedroom, she does have a door alarm on her room. I don't leave them alone unless it's the 2 seconds it takes me to go to the bathroom or to be right behind them. You know, like if we're all downstairs and we're going upstairs to the kitchen, they run up there, and I apologize that my physical health isn't the greatest, but I cannot run up my stairs. Other than that, I do not leave my children unattended. I am consistently with them, watching them. If they play outside, I am not directly right next to them, but I am sitting on my deck watching them outside.
In your response to the recommendation that you have a psychiatric evaluation and a hair follicle test?
No.
Okay. Mr. Rooney, any response to those recommendations for you?
No, I agreed with the
Okay.
hair follicle test. I had no problem with that, and I'm currently in counseling as. Can you hear me now?
Yeah, you're breaking up a little bit. Go ahead.
Can you hear me now?
In counseling.
Sorry, I'm currently at work and I don't have the best service.
Okay.
Yeah, I'm currently in counseling as is. Because of my work schedule, I have to call and schedule weekly appointments, and I have no problem with the hair follicle test. I told the guardian ad litem from the beginning that I have no problem going. I'm just now starting a new job, so I would need at least 3 weeks before I had the money.
Okay. Ms. Call, where would you recommend the psychiatric evaluation be completed at?
One moment, Your Honor, the name is escaping me. I'm still new to the Kelso area, so I'm still, I have it one. I apologize, Your Honor. Can I provide that to the parties?
Sure. Okay.
I have one. I'm just.
All right. So Ms. Call has made a number of recommendations. I'm gonna order some of them, but not all of them. That doesn't mean I'm not going to order all of them as we go forward. But I don't know that it makes sense to give everybody a lot at one time. So for Mr. Rooney, I am going to order a mental health evaluation. You could do that either at Columbia Wellness or Core Health, and also a hair follicle test.
Yeah.
Provide the results of the evaluation to Ms. Call, along with the result of the hair follicle test, and then she can file it with the court once she receives it. For Ms. Emerson, I'm going to order a psychiatric evaluation. Ms. Call will have to contact you as to where that will be, and also a hair follicle. Talk to Ms. Call about providing her a current assessment of your current counseling. And I don't think we're talking about turning over the counseling notes. We just want a conclusion from your counselor as to what the issues are. I'm not going to order the parenting class at this time. I probably will in a future date. And we will hopefully soon talk about increased visitation. Final GAL review is June 28th. And maybe that should be our next date together, is June 28th.
Your Honor.
Ms. Looney?
Thank you, Your Honor. Just before we go on to the next case, if I could ask a clarifying question. Has Your Honor found adequate cause for changing the parenting plan on this case? If so, the state would need to file a notice of appearance to be present for child support. The child's receiving state medical.
I don't believe I found that at this point. I don't think there's an order to that effect. There were concerns raised by the father, and we are exploring those issues at this point.
Thank you, Your Honor.
Okay. All right, Mr. Rooney, any questions?
No, Your Honor.
Ms.
Sorry, I have very bad.
That's fine. Ms. Emerson, is there any questions?
No.
Okay. And Ms. Call, anything further? Okay.
No, Your Honor, thank you.
We'll see everybody back here then on June 20th. And I note that everybody has signed off on the dissolution documents.
Yep.
So if you give me, well, I'll tell you what I'm going to do. I will go through and sign those after the docket, but they should be entered today.
Okay.
All right.
All right. Thank you.
That's it. And thank you very much. Thank you for getting that completed.
Thank you.
You bet.
Bye.
I see Michael Teft is Alonza Morris Teft here. All right, Mr. Teft, I don't hear from her. I'm going to pass this for the moment, and then we'll go. I see Rebecca Mills is here. I actually was a little surprised to see this on the docket because I think we're going to take up a lot of issues next week. Was there a issue in particular that you wanted to address today, Ms. Mills?
I had one quick one, but I don't see Samuel here, and I feel like he would probably need to be here.
Okay.
I was hoping, I know that we had ordered a hair follicle test, and I was hoping that if he hadn't taken it yet, we could switch the 12 panel to a 17 panel, because that will test for what he admitted to actually taking. The other one won't test for that.
All right. We made a note about that. We'll take that up next week. Again, I appreciate you being here, and I'm certain I put this on the docket for today, but I've been putting all of the issues off for next week, and I hope to address many of those at that time. Okay.
Okay. Thank you.
All right. We'll see you then. Next is Aaron Farmer and Tanya Hansen. I see they're both here. Both of you have filed parenting plans that you'd like the court to consider. I'm going to give you each a chance to comment on that, and then I'm going to talk to you about what I think we should do at this point. So, Mr. Farmer, do you want to go first?
Yeah. Since 2020, we had a written agreement stating that I will get them from Friday when they get out of school till Tuesday at 6 p.m. and it's never been an issue. I wrote out 3 different ones. She signed off on every single one, dated. I have copies already submitted. I had my wife sign off on it as well as a witness, and asked if she wanted to meet up to get it notarized so it's more official, so we can avoid the whole court, all that. And she said no. Instead, she wanted to get a parenting plan. And this just recently became a problem after I went in and decided to get food benefits for the kids. And now it's a huge deal to her. And so she basically threatened with the parenting plan. So I filled one out and turned it in. And I'm just trying to keep it the same as it was, not trying to change anything.
Okay, thank you. Ms. Hanson?
Yeah, with the whole food benefits, that is not the reason why I wanted the parenting plan. It's safer for the children to get it so that it can be safe. With other cases going on, I don't want the same thing to happen. So I feel like it's safer to have a court order, and I am asking for a little more time because I don't have time other than school days. So I would at least like a weekend in between the month.
For some period of time that both of you have cooperated, it appears you've entered into various agreements. And because of that, I think the way that we need to move forward, and it is a requirement of the court at this point, before a parenting plan can go to any trial, is to send them, both of you, to a mediation service to discuss the parenting plan. And so I'm going to sign that order, and the mediation service will reach out to both of you to find a time that works where you can get together and discuss the parenting plan. I want to share, I guess, 2 thoughts as you go to that for both of you to consider. First, right now, the mother doesn't have any weekend visits. And if we're looking at the best interest of the child and the ability of the child to just have fun with her mother, then it seems to me some weekend visit should be there. So you might want to just consider that going forward. Secondly, I'll just say the agreements that have been entered into are probably not going to be controlling on the court. They would be some evidence of what the parties agreed to and what they intended, but they're probably not going to be controlling. So with that, I'm going to order that this go to mediation, and hopefully you can work out a parenting plan that really meets all of your needs. And so, again, they will reach out to you and schedule a time. By the way, on the cost, I'm ordering that you pay equally, but I think both of you have asked that your costs be waived, and what they charge at the mediation service is a sliding scale based on income. So it's not very much to begin with, and in many cases, they'll just waive the fee. Okay, so you're not looking at a huge expense. If it cannot get resolved at mediation, then you'll be back in front of me, and we'll start taking steps to determining what kind of parenting plan should be entered. I want to set a review date, which is about just a little under 5 weeks from now. So I'd like to be back in this case on June 28th. And hopefully you'll reach an agreement. But if you don't, then we can get back on track to move forward. Until you go to the mediation, and if you don't resolve it, until you come back on June 28th, then I want both of you to follow your current agreed plan. So there won't be any changes in that. And when you go to mediation, then you can discuss that. Okay.
Okay, thank you.
All right,
Thank
Mr.
you.
Palmer, any questions?
Nope.
Okay.
Your Honor, I just want to know if I was in the right courtroom for the contempt of court.
If that's Ms. Taft, yes, you are, and I'm about to call your case.
Okay, sorry. Thank you.
There's a Raylene Aguirre, and I'm not sure you're in the right courtroom. Do you want to tell me what docket you're on? Right, so we're back with Teft versus, well, Alonzo Teft versus Michael Teft.
I'm here.
All right, and I think this is a motion for contempt brought by Ms. Teft, so I will hear from you first.
Yeah, Michael Taft was supposed to pay alimony, also pay the repayment plan of money that he stole from me when we were together. That was signed by a judge. He knew about the he knew what he was supposed to pay, and he intentionally didn't pay it. He literally tried to say he didn't have, but yet he's buying new cars, new windows, shield, new tires for his cars, and just doesn't care about paying it. And so I had to file contempt of court.
Right, thank you. Mr. Teft, any response?
I object to her motion that she filed for contempt. And I also was looking to get maybe the specifics on how to contest a default judgment, because I just don't understand how a judge could even just, like, I understand that I didn't show up, for the divorce hearing, but I just don't understand how a judge could sign off on certain matters without taking into consideration certain factors.
All right, just hang on a minute here, okay?
Well, Your Honor, if I may,
Yes, please.
Michael had plenty of time to respond to the divorce. He chose not to respond to it. That's why I had to file for default. I've told him over and over. I gave him warnings. I texted him. I called him. Even when he moved out, I gave him plenty of warnings to respond to a divorce, and he chose not to respond to it, and that's why he got filed for default. And that's why I had to file for that.
It's like Judge Basher signed an order of default on January 5th, 2023. And then after that, the decree of dissolution was entered. And that called for both a payment of $650 a month in spousal support, and also judgments of $1,730 plus $1,200, which I think is the $1,313 or $3,113 that Ms. Teft asked for.
Yeah, that's the money that when he had kicked me out, he stole my tax refund and also my stimulus, and lied and kicked me out and had me on the street for about, I want to say a month and a half, and then he let me back in the house, and then he had me assaulted by his baby mama, and used that money that was rightfully mine to buy a car that was broke down. So that's why I asked for the repayment back, because that was rightfully mine that he stole, that he shouldn't have gotten.
I'll note that the order says that the respondent was to pay that money back in 30 days. So, Mr. Teft, there's a motion called a motion to set aside a default. I can't tell you how to bring it or how to write it. I'll just tell you that's the motion you need to look at bringing if you want to challenge the default that was entered in this case. And I can't tell you how that will be decided, but you can look into that. I am going to find a contempt in this case on those two payments. I'm going to make a couple changes in the order. The order calls for jail time. I'm going to strike that. We're not really near a jail time order at this point. But the order will, I'm not going to order any sanction. I'm just going to indicate that the $650 is owing for May. And I believe it's the 5th of each month, so it'll be May. And And the 3113 is owing that needed to be paid within 30 days of April 14th, and that hasn't been paid. So essentially, there isn't any additional money owing as a result of my order versus what was ordered in the dissolution decree. And Mr. Teft, should the order to set aside the default not be granted, then the order is going to stand and you need to pay $650 a month in spousal support. All right, thank you. I've signed that order. And I think that's the end of our docket today.